Be on the World Wide Web.
Oh, wonderful.
There we go. Okie dokie. How long do you all anticipate this lasting this morning?
My understanding, Mr. Jenkins, is we were set for like 15 minutes. Is that right? Just to give the judge, I think, an idea of what we're doing maybe on the 24th.
Yes.
Yeah, that's what I thought. So just not too long, Miss Insinger.
Thank you.
Mm-hmm.
You don't need this.
Sorry, I had to open up the other part of the computer. Thank you. This is the Bastrop County Court at Law, February 3rd, 2021. The court will call cause number 2020385 and the matter of the marriage of Browning for the purpose of considering a status hearing regarding the status and procedures for upcoming final hearing. Who is the original petitioner?
Yes, Your Honor, I'm Mary Gunn, and I was the petitioner, and I'll just introduce you. This is Allison Hurd. She's an attorney that's joined me from Columbus. So I just wanted to have her meet everybody. She's sitting in with me today. Okay. But I am the petitioner. We filed this in September.
Okay. Mr. Jenkins?
That's right, Your Honor. Is that your question? That yes.
No, just make an appearance on the record.
Will Jenkins representing Sarah Browning, the respondent, counter movement.
Okay, let me first ask what we anticipate the trial issues to be. And I understand y'all had a Rule 11 agreement with regard to sale of a home. Is that correct?
Yes, Your Honor. So what's happened in this case thus far is the petition was filed, an answer has been filed, and we have a Rule 11 with regard to the sale of it was an investment property, and the sale proceeds, that closing happened, and those are being held currently in my trust. It was a little over $187,000 that are held in my trust. And we're actually set for a temporary orders hearing, Your Honor, on the 24th of February. We have not. So although I'm hopeful that we could hopefully reach an agreement in between now and then and make it a final, so we could just be done with this case, but we have not had any actual temporary orders in place since the time we filed.
Okay, and what do you anticipate those issues to be?
So I'll let it's Mr. Jenkins setting, okay. I think for the temporary order. So I'm happy to let him speak.
Okay, Mr. Jenkins.
The issues will be child support, possession and access. We have multiple allegations of violation of a standing order, which I haven't filed a motion for contempt yet, trying in an effort to get the case resolved. But for instance, Mr. Browning has purchased a home and moved to Victoria after he filed and used community property to pay the down payment. So we have no orders in place for possession, conservatorship, or support. Very little support has been paid. One lump sum of $3,000, which is a substantial amount of money, but both these folks are high income earners. So we have no orders in place for possession, access, conservatorship, and support. And those are the biggest problems. Nobody has exclusive use. Doesn't seem like Mr. Browning is following the standing order. And the other issue we have is they own a community property townhome that it's my understanding, Ms. Gunn can correct me if I'm wrong, is set to close on the 10th of February. And I would like that money to be captured in Ms. Gunn's trust account until we have an agreement or until we have a court ruling on that matter. It's I think around $75,000, and it's a townhome or a duplex in Victoria that I believe Mr. Browning is solely on the note and deed of trust, and we're concerned that he'll close it and have possession of the proceeds, and we just like them kept in Ms. Gunn's account, much like we did with the other property.
Okay, and has there been a dispute about what the possession and access has been?
I don't believe so. Ms. Gunn may speak to that. I believe they're sharing. There's 3 children, and I believe they're sharing the children.
Okay.
For now.
And are they? How old are they?
They're young. I think from 6 to 14. But again, Ms. Gunn may have to check her petition. But 6 to 14, I would say.
Well, you say he moved to Victoria, and then where does your client live?
In the marital.
Sorry.
In the marital home in Cola Vista here in Bastrop.
Okay. Yes, ma'am.
Sorry, I tend to overtalk on Zoom. Your Honor, my client and Mrs. Browning are both nurse anesthetists. I have a hard time saying that word, but nurse anesthetists at St. Mark's Medical Center in LaGrange. They were both living in the marital home in Bastrop at the time that my client filed. The children were going to school in LaGrange. There's 2 younger children, 4 and 5 years old. There's an older child that looks to be about, I think 14, 15 years old, a daughter. And then my client adopted that child. So she's older than his son, who's 13 and not a child of this marriage. So we had 4 children living with the parents in Bastrop. The children, I think, were going to school in Smithville, but the littlest ones were going to Sacred Heart private school in LaGrange. So when the petition was filed, I believe Mrs. Browning then unilaterally withdrew the children. And I'm not saying she violated the standing order, but she unilaterally withdrew them from the private school they were in LaGrange and put them in a school in Bastrop. I think another little private school in Bastrop. And so that caused a bit of complication because both of the parents were working in LaGrange, and now we had young children no longer in school in LaGrange. So I would disagree that the possession schedule has been perfect, but I think my client was trying to see the children and not able to, but I think it's now been better. I think we've kind of fallen into a little bit more of a standard visitation schedule. My client is not trying to fight for custody. He simply wants to have time with his girls and be able to see them regularly. My client and his son moved out of the marital home in Bastrop, leaving mom with the 3 girls. And he has an apartment that he has in Smithville. So this idea that he's completely moved and he now lives in Victoria, that's really not completely accurate because he has his apartment in Smithville, but that's all he had. It's a pretty small apartment. And so when it was time to start having the girls and having space, he is from that Victoria area, which is where a lot of these investment properties and things were. So he, just like your client bought a new vehicle and removed funds from the account, maybe it was right before the standing order, he did a purchase to own, bought something in Victoria so he would have a place when he has the children to have all of them. So my client makes about the same amount as Mrs. Browning. They both do really well at the hospital. my client has been putting in a lot of the money each month towards this investment property, Your Honor, that just sold. So there was countertops and landscaping and all sorts of things that had to be paid. And so although he gave money to Mrs. Browning and continued to keep the kids on the health insurance and has also paid for half of their private school, he has not been paying, and then he's been paying all those other bills for the investment property. He has not been paying per se child support. Now, I have no problem, and I've told Mr. Jenkins this, that based upon his earnings, I think he's the maximum 9,200. I don't have any trouble having him pay statutory. We don't have any issue with that. But I think Mrs. Browning wants above statutory child support. She also wants him to pay for the school, things like that, which, you know, that may be something that we can agree upon. But this idea that, you know, she's been left in the wind with no money, I just would disagree with that.
Okay, so there's procedurally, this is going to be by Zoom. So
yes.
I would like for you to exchange your documents with each other and with a request to stipulate to the admissibility of the documents and have them to Haley no later than 48 hours before the hearing. A lot, and this really it's really better for Zoom, but it ought to be the rule anyway, that we really shouldn't spend any time on those things that really aren't disputed. And most documents are just not disputed. You might dispute what they all mean, but you usually don't dispute the actual document. Then you'll have to go through a lot of effort, time, money, attorney's fees to get them authenticated and get them and accepted to the hearsay rule. And when really nobody disputes that they should be just admitted. So I would like for y'all to do that because we're talking about time, and let me explain so that everybody can understand what we've been doing. In the Zoom world, we're giving everybody their specific time frame. When we had a docket where everybody started at 9, pretty much you got on the docket. Pretty much everybody got reached. We would handle the early hearings, the short hearings and agreements first, and then work into the longer hearings. But on Zoom, so that you're not sitting in a wait room, a virtual waiting room all day long, we give you your specific time. So therefore, we're not able to overbook in a sense like we could overbook when we had a regular general docket. So whereas before you could just say, I want up to a 2-hour hearing, you got it automatically. Now we're doing status hearings because we want to know really how much time you're going to take, because you were literally keeping somebody else off the docket when we give you 2 hours. And so that's why we're handling these this way. And outside of Zoom, it's beneficial to talk about some of these things. So how many witnesses do you intend to bring, Ms. Gunn?
Your Honor, besides my client, I may have 2 other witnesses.
Okay. Do you anticipate that they're lengthy?
But honestly, if we're looking at, and I'm kind of talking to Will too, if we're looking at, Will and I have tried really hard to go back and forth and try to resolve this case in full. So, and so I filed a motion for mediation because we're not quite there, but I think we're close. If we're just looking at a temporary orders hearing, if we're talking about child support and we're talking about visitation and we're talking about injunctions, and my client he's not selling any property, that's not going to happen. That would be against the standing order. So that's not going to happen. So I'm not really sure. I don't really think I know Mr. Jenkins has requested 2 hours, but I'm just saying, we're not fighting over custody. I don't really know a ton of how long. I don't think this case should take that long if we have to take it, but I've requested that maybe we go to mediation. We've got 3 weeks. Maybe we try to go to mediation and just resolve the whole thing. But at a temporary orders basis, I don't see this case taking that long because I don't think there's a ton of issues.
Okay, Mr. Jenkins.
Your Honor, 2 hours isn't a lot of time, and we're going to be asking that Mr. Browning pay child support in excess of the cap based on the children's proven needs and the fact that they've been used to private school and she can't go it alone. and the fact that she has received basically 1 month's payment since September. So we do think that 2 hours is needed for temporary orders. I don't agree to go to mediation prior to temporary orders. I don't agree to go to mediation prior to any discovery being conducted. I don't anticipate more witnesses than Ms. Gunn would be calling because to an extent, she is right that there hasn't been discovery. We just don't have any orders in place protecting property or who's going to pay what bills. And it has caused some problems with the case being settled. And I'm not willing to incur the expense of mediation prior to a temporary orders hearing. I've never gone to mediation prior to temporary orders hearing without any discovery, and I don't think that's beneficial. The case should resolve itself with some communication between now and then, but if it doesn't, I don't think 2 hours is too big of an ask.
Okay, and who do you intend to call as witnesses?
Other than my client, maybe 2 people. I mean,
Okay.
I
So
don't know.
both have mentioned 2 people. Can you both just say who they are? I'm trying to determine whether it's 2 hours or not.
Yes, Your Honor.
At this, go ahead, Mary.
No, go ahead, Mr. Jenkins. Sorry.
At this point, Judge, I don't know who they are. We're in our mind extremely close to settling the case, and it just didn't happen. But I can't imagine me calling more than 2. I don't know who they are.
Okay. And that's part of the rub that we're because we're having others of these types of hearings, and that's a fairly consistent answer that and what we're trying to move away from is not knowing, requesting 2 hours but not knowing. It was perfectly fine when everybody didn't get their, when you just everybody came in at 9 o'clock, right? So and you just marshaled your people because you had set for 2 hours, and if the docket looked too long, we stopped it and you had to get a different docket date. But this, we don't, instead of booking 10 to 12 hours of docket, you can book 6 at the most, and maybe 6.5. And so as a result, a lot fewer people have to have their cases set out further if that's the case. So it's not necessarily a problem with the 2 hours, but I really do want everybody thinking in advance, who am I going to have to call to prove this? And so correct me if I'm wrong, but it sounds like, so absent a motion to for enforcement of the standing order, it sounds like a joint managing conservatorship with a standard visitation, and hopefully that the parties could coordinate any extra time they ever want to, just by like, hey, pick up the phone. But not something, you can't micromanage those in orders. You have to, give the general stuff. And then sounds like the big question is simply whether or not we would order child support in excess of the statutory top. And so therefore, Mr. Jenkins has the burden of proof. I'm not sure what other witnesses are necessary to show that, if we're not talking about I don't mind that there is a little bit of cushion. Hey, I don't want to say 1 hour because that's all I could do with my client. But I guess we can just leave this for 2 hours. I don't have a problem with that. We're growing into this, but we should expect more of this even when we go away from Zoom, because we do want people to have talked about those things in advance. And what we get so many times with extra witnesses is not really any extra testimony whatsoever. There's like I had a hearing that I let go long yesterday because it was a CPS matter and went 3 hours, and we probably had 10 minutes worth of real testimony. It's just that everybody said the same thing over and over and over again and fought with each other. So 2 hours is fine. I want to make sure y'all do the documents. I won't order the mediation yet, but you should expect that you wouldn't have a contested final hearing without mediation. Are there any other issues? Because I'm not thinking of any off the top of my head. Any other issues y'all needed resolved?
No. And Mary, would you like to speak first?
Sure. I mean, I'm just going to I don't mind saying what I've told my client to do. I've told my client to pay statutory child support of $2,421.30. I told him to pay that today, so he's paying it. I told him to continue everyone on the health insurance and his wife and medical, pay all that. He's doing that. I told him to continue to pay half of the children's school, even if it may or may not come to the end of it, and he's going to do that. I've told him to have his visitation schedule with his kids based upon what his wife has allowed him to do. He's going to do that. So, you know, the issue of back child support and offsets of what people have paid, I really think that's a final hearing issue. And I don't disagree that we're going to address that. But honestly, I think the issues are, to me, I think the issues are resolved. I mean, that's what, and I don't mind saying we're going to do that and draw that up in a Rule 11 agreement. If you want us to move forward with discovery, I'll send it to you today and let's go to mediation. I just feel like these are two good parents, professional people, have done pretty well with no orders in place in September. I don't know what I don't exactly, there's a lot of mud and divorces, of course, but I feel like we can move these people along, not waste Judge Eskew's. Now, I'm not saying that we're wasting your time, Judge Eskew, but not waste your time when we've got all these other people who have probably likely greater needs than we do, and move on. And if we want to reserve those issues for, I don't mind reserving issues for cap of child support or more than the cap and all that stuff for final and payment of school, but that's what my client's going to do now. And he's been paying a lot of, we can get into that in the final, but I mean, that's where we are. I just think we're making a bigger, and I'm not saying you are, Will, I'm not saying that. And I'm not saying Judge Eskew, I'm just saying, I think we should be able to move forward with this. But I mean, that's what I've told my client to do. And that's what he's going to do. And he's not selling any property because that would be in violation of the standing order. So no.
Okay. So, private school.
Your Honor, can I respond?
Sure. I
don't believe any of that speech was conducive or helpful to settlement. And it probably was a two-step backwards thing and probably shouldn't have been said. I certainly don't feel like I'm wasting the court's time. I guarantee you my client doesn't feel like she's wasting the court's time. There are disputed issues. Mary may not like that we're disputing and not doing everything she says, but that does not mean that our requests are meritless or insignificant. So I don't think that was real helpful. That being said, the issue I do have, and if we're going to have the temporary orders hearing, I absolutely will be filing a motion to enforce the standing order. And I will represent to the court that he absolutely has bought another house since he filed in Victoria, way after he filed, and he has used community property funds to pay down on that house. So that issue will be added to the temporary orders hearing. Other than that, I do think the court has a pretty good read on the outstanding issues. The only thing that I need resolved is the townhome that is, if it is going to be sold, I'd like the proceeds to be captured in Ms. Gunn's trust account. If it's not going to be sold, that's okay.
Okay, so just for purposes of clarification, one, if we're dealing with an enforcement on that and we have extra funds and extra assets, don't expect something draconian. Expect that it would be handled financially. Where you have to get draconian is when they've taken the only asset or few assets that somebody has and poured it into something of their own, hidden it, or done anything like that. If there are assets, if there are places to go get it and to make it all right and fair, that's the first place to look. So yeah, it may be worthy of some consideration there, but I wouldn't
No, that's not to say, not having heard the evidence, I don't know how intentional or bad that would be. So you know, the answer to every question is it depends. With regard to paying extra, if the issue is school, you know, the answer, we don't have too many cases around here where we've ordered excess of the statutory top. It has happened. The answer there again is it depends. How much more? What has been their lifestyle? Private school is a difficult issue because usually those decisions are made together and there's no guaranteed right to continue a private school. So a lot of that comes down to how much the income really is. Let me float this out there for your consideration in the future. If there are assets, I mean, I'm gonna make up something. What if he says, I don't really want him to go to private school? That's always been your call. That's always been your decision. I don't really want to. And now we got two homes to pay for, not one. And I don't want to do that. And she goes, no, that's really important to me. You know, if y'all are selling things and if there's money there somewhere, there's always the possibility of saying, in lieu of exceeding child support ever, I'm going to give you this asset or give you funds out of this sale or something. And then if you feel like you want to go put them in a private school with that money, then that's your choice. So that there are avenues there because the code talks about paying some or all of child support in lump sums. So there's always a possibility of that, but I don't know what his real feelings are about private school. And I don't know what her real feelings are, but sometimes they also don't last. And then kids start wanting input into those things down the road too. So again, it depends. I'm just saying that when you do have some assets, or even if you don't have them, you have the ability to go borrow and then put the decision back to someone else. There's always those things. You need to pursue those things and talk about those things. So just food for thought. Is there anything else that you need me to address?
The proceeds of the townhouse that's set to close in 8 days.
I think he already said that she's going to put it in. Ms. Gunn, are you going to do that?
My understanding is the townhouse is not selling. It's not going to sell. If that changes, absolutely, those would need to be captured. But I didn't know anything about that until I think your client and my client had been talking about putting it for sale. So I told my client as soon as I heard that, no, unless we have an agreement, that would be in violation.
Would you both agree on the record that if it does sell, that the net proceeds will then be put into your trust account, Ms. Gunn?
Absolutely. If it does sell, absolutely, we would capture those and I would hold them just like I'm holding the other sale proceeds. Absolutely.
Okay.
Yes, sir. We agree to that.
Okay. All right. And ma'am, tell me your name again.
Allison Hurd.
Allison. If you're ever around Bastrop, stop at the office and meet my staff, and we'd love to welcome you.
Sounds good. Thank you.
Okay. Is anything further?
No.
Okay.
No, Your Honor.
And don't forget about the document exchange.
Thank you.
Thank you.